Hello, I'm Amanda Moore. Welcome to the Advocacy Exchange for September 2017. The Advocacy Exchange is our monthly broadcast, our monthly conversation with advocates advancing change. I'm the director of the Clearinghouse community, and both the Clearinghouse community and the Advocacy Exchange are brought to you by the Sargent Shriver National Center on Poverty Law, a national leader in advancing justice and opportunity. And my guest today is Esme Caramello. I'm so glad to have her here with me. Esme wears a couple of different hats. She is a clinical professor of law at Harvard Law School, and she's also the faculty director of the Harvard Legal Aid Bureau. She's joining us today from Cambridge, Massachusetts. Hello, Esme.
Hello.
Glad you're here.
I'm glad to be here.
And Esme is she also co-authored this month's Clearinghouse article. It is called Combating Tenant Blacklisting Based on Housing Court Records, a Survey of Approaches. And you can find that at our website, which is povertylaw.org/clearinghouse. It describes the barriers that a housing court record can have on tenants who are trying to find housing and talks about advocacy strategies that have been used to mitigate that harm. And that's what we're going to talk about today. But before we do that, I want to tell you how you can be part of our conversation. I see that a lot of you have found, and lots of you are still finding the live chat box on YouTube Live. I know you're watching us through the Shriver Center's YouTube channel. That's how you can communicate with us. I see lots of you are letting us know you're watching, telling us who you are and where you're watching us, which is great. We'd love to hear from you. And as we have a conversation today, we'd love to hear your questions, comments, feedback, insights, whatever you'd like to share. And if live chat is not your thing, you can also send me an email. My email address is amandamoore@povertylaw.org. That's Amanda Moore, M-O-O-R-E, @povertylaw.org. So you can also send questions that way. For all of you who registered for today's broadcast, and maybe your colleagues registered but couldn't tune in today, we are glad you're all here, and you'll get a follow-up email in a couple of days, and that email will contain a link to a recording of today's broadcast as well as a link to Esme's article. And I should mention that Esme had a co-author, Nora Malberg. Nora could not be here today because she is in a judicial clerkship that she just started. At the time of the article, she was a Skadden Fellow at BPI Chicago. Let's get started talking about why we're here today. I'll say hello to all of you who've joined us. I'm afraid I can't acknowledge all of you individually right now, which is a good thing to have happen. So Esme, in the past, in the Clearinghouse, we've covered a lot about how criminal records can be a barrier to finding housing. So tell us what you mean about a housing court record and how that type of court record can also be a barrier to someone being able to find housing.
So I suspect that most of the people on the call already know this, but when we started this, we started thinking about we started seeing how our clients in eviction cases, sort of regardless of the type of eviction and regardless of the type of outcome of the eviction case, would subsequently have trouble finding new housing because their landlords would find out that they had been the defendant in an eviction case and would discriminate. Basically, future landlords, potential landlords, would discriminate against them on that basis. But then the more we looked at it, the more we decided to broaden that to just any kind of record of appearing in any kind of case in a housing court, because tenants who file cases against their landlords, for example, to get conditions of disrepair fixed, might face an even greater barrier to future housing. And of course, landlords find out about these case records because in most states and in most circumstances, they're public records. A landlord could theoretically go down to the courthouse, pull files there, and be able to see all the public records. More commonly, what's been happening historically is that landlords would buy tenant screening reports from tenant screening bureaus, which are these companies that are set up specifically to pull together reports on tenants. They'll include the eviction case history, they might include criminal history, they might include a credit score or something like that, and then they might make a recommendation about whether this landlord should rent to this tenant or not. But more recently, everything's online, right? And it's in many states, it's online for free, 24 hours a day, forever. And so that adds just yet another dimension. And at least in Massachusetts, where I am, we saw a dramatic increase in barriers to finding new housing once all the housing court records went online. And we use the word housing court sort of, generally to mean any court where housing cases are heard. So we started to look at it and say, like, what can be done? And the goal of the article was not to, it's not a spellbinding read, but the goal was to sort of say, like, what is everybody, we know everybody in the country is dealing with this. What are all the what's the range of approaches that people have taken, and where have people had successes, and like, what are the conditions on the ground in those places? And so we're trying to just create a resource for people who might want to tackle this issue.
Got it. And, I mean, I may be a little biased, but I wouldn't sell yourself short. It's pretty spellbinding. And I will remind everyone, you can find Esme and Nora's article at the address on your screen, povertylaw.org/clearinghouse, and we'll also send out an email with that link in it afterward. Thanks to all of you again who've tuned in. We've got Kelsey in Nebraska, also Robert in Nebraska, Carly in Pennsylvania, Igor in Tulsa, Oklahoma. So thanks for tuning in, everyone. Feel free to send us your questions through the live chat or through my email address, which is now on the screen, Amanda Moore, MOORE, @povertylaw.org. So, Esme, that's a good overview of the situation, but I have to ask, I mean, is there a benefit to having those housing court records and landlord access to them? I mean, do landlords not need to see those to know if they're potentially getting a tenant who may end up being troublesome?
So it's not as if there is absolutely no value to landlords to knowing a tenant's rental history. The problem, of course, is that the records that landlords are seeing and the recommendations they're getting from the tenant screening bureaus are not indicative of whether someone is a good tenant or not. That's a problem. So, for example, there are widespread inaccuracies in these databases. There are widespread inaccuracies in the tenant screening bureau reports that report on the databases. Sometimes James Fishman, who's one of the lawyers in the country who's been a leader on this issue, has just filed a class action in New York alleging that CoreLogic, one of the major tenant screening bureaus, just doesn't update they'll go get a record. This is not, I'm boiling down way more than it's a beautiful complaint that people should read if they're at all interested in this issue. But one of the issues is that CoreLogic will get something in and they'll report that the case is filed, but they won't report that the case has been dismissed or withdrawn or otherwise resolved in favor of the tenant. So they're really not reporting accurate information. Clerks input information wrong. I know in Massachusetts, our court system is dramatically underfunded. I'm sure that's true in other states. There's also the fact that this is a tiny piece, even if all of the records are accurate and reported accurately, this is a tiny piece of who a tenant is and what his or her situation is going to be going forward into a new tenancy, whether they're going to be a good tenant. And instead, what this creates is an opportunity for landlords to simply say, if a person ever tries to assert their rights, I don't want to have anything to do with them. So it really creates a major access to justice problem, which is why I got really interested in this topic, because it wasn't just about, can this person find housing, but can I say to a tenant who's coming into my office looking for legal services, yeah, go ahead, fight for your rights. You have rights in this situation. And then they say, but won't future landlords see that I asserted my rights, and won't they discriminate against me? And will there be anything to be done about it? And I would have to say, good point. So that doesn't feel right.
Right. We have had a question come in that actually kind of anticipates the question that I was about to ask you. The question came from Carly, and she's asking, can we make a disparate impact argument against this form of discrimination, which was what I wanted to ask you. When we're thinking about this as a comparison with the criminal records and housing issue, we've seen that there certainly are some disparate impact arguments to be made. There's a definite race equity angle to it, and lots of fair housing implications. Do we see the same type of issues when we're talking about housing court records and tenants?
Certainly, and I think I think that's a great question. There is certainly some academic literature, although not enough to cover the entire country and all the situations, showing that evictions themselves have a disparate impact on people of color. Matt Desmond showed that in Milwaukee, Black women were more likely to be evicted proportionately, dramatically more likely. I have a couple of former students who have written journal articles where they've either used Matt's data or gotten other data for New York, Toronto, and again, another one in Milwaukee showing that, for example, Hispanic tenants who are living in non-predominantly Hispanic neighborhoods are more likely to be evicted among people who are at risk of eviction, et cetera. So there is data out there. There are data out there. Eric Dunn, who's been another leader on this question of tenant screening and blacklisting, he used to be at the Northwest Justice Center in Washington. He's now at the Virginia Poverty Law Center, I believe, certainly in Virginia. But before he left Washington, he got a disparate impact case actually started on behalf of a tenant. He worked with the sociologist to gather statistical proof that eviction records disproportionately impact people of color. He has a tenant who applied for a place. The landlord said, "I won't even consider you because you've got a record of having a case." And this is a tenant who would be a very good tenant for various reasons. She had gotten a Section 8 voucher in the meantime. There's really no reason she wouldn't be able to pay the rent in the future. And so he's brought a disparate impact case. And I think that's a really we've cited the case in the article. It's Nikita Smith versus Wasatch Property Management, and it's filed in federal court in Washington. So that's a good example. And I think that the Department of Justice memo on criminal records and the disparate impact of screening based on criminal records lays out a good roadmap, which is analogous for the tenant context. The problem is the data exists in the criminal records context. It exists less so in the housing context. So you, as the local advocate, have to figure out, how am I going to compile the statistics that I need to make this case? And I think Eric's provided a great example of how to do that.
Great, thank you, and thank you for the question. So let's talk now about some more strategies, some of the strategies that you lay out in the article. So the article has sort of three main categories of strategies. First would be just removing the housing court records from public access. The other two are more about those type of tenant screening bureaus that you're talking about. And so one of those would be regulating the content of the reports that they produce, and the other would be regulating how those are used, those reports. So let's talk about those three kind of big buckets in turn. So first, how could we remove housing court records from public access?
So California has a really great example of this. In California, your eviction case does not become a public record at all unless the case is resolved in favor of the landlord within 60 days or after 60 days if it's resolved in favor of the landlord because the landlord wins at trial. Otherwise, it's simply not a public record. And so it can't be found, it can't be reported, it can't be looked up online by a curious prospective landlord sitting in their pajamas, one Saturday night. So that's a great example. Whether that can be done in a lot of states, whether there's the political will is one question. The other limitation on that is that some states have very strong open records laws. These are sort of like government transparency, open government laws. For example, Eric Dunn, who brought that great disparate impact case, had tried to do something like this in Washington, and the Washington courts have been clear that Washington courts had been clear that our open records law and our constitutional provisions protecting the public's access to information makes that sort of what he sort of concluded to be impossible in Washington at this time. So whether you can get as far as California, it's a great model. It's a great model to take to your policymakers in your area and say, like, we're not the only ones doing this. There are also examples of specific kinds of cases, like post-foreclosure evictions, where advocates were able to have more success getting those automatically sealed. Illinois and Minnesota are two examples. And I think these examples, combined with the examples outside the housing context, like juvenile court records, and other things where we sort of recognize that the balance between public access and the personal impact of having this information in the public domain is skewed in favor of privacy. You can use those arguments to support that. Gotcha. Automatic sealing. And then, of course, there's discretionary sealing, which would be more on a case-by-case basis. And I don't know if you want me to talk about that or other things?
It's up to you. I guess our viewers could let us know. We did have one question come in. What is the name of the New York CoreLogic case?
Yeah,
Do
great.
you have it handy?
Okay, so it's filed in the Southern District of New York, and it's Feliciano versus CoreLogic Safe Rent LLC.
Great. Is that in the article? I can't remember.
I hope. I don't know whether it was filed ahead of time or not, but I can make the complaint available to people, on afterwards.
Great. I was going to say, we can also, as I said, everyone will get a follow-up email. We can include that case in the email, so be on the lookout for that. All right, so let's move on to sort of the second big category of advocacy strategies that you talked about, which is those tenant screening reports that we get and regulating the content of those. So can you give us some examples of what you mean there?
So as I mentioned before, some of the problems with Tenant Screening Bureau reports, one of the problems you see is that the information is not accurate. So Tenant Screening Bureau reports are covered by the federal Fair Credit Reporting Act. That act can be cumbersome, hard to use, but under it, theoretically, a tenant would have the right to get a copy of their Tenant Screening Bureau report and to challenge any errors, and then there's a back and forth process. And if the Tenant Screening Bureau doesn't fix it, there could be litigation with attorney's fees. I've been contacted by consumer protection lawyers who say, hey, we should be doing more of this work because it's fee generating, and in a market where legal services are ridiculously unfairly underfunded, this could create a practice area that might be self-sustaining. So that's one possibility. Some states have gone further than that because that process is so cumbersome and said, like, let's create state or local laws that allow tenants to put into the Tenant Screening Bureau reports more of their side of the story. So whether it's more details about the eviction case, information about any information they dispute that's in the Tenant Screening Bureau report, et cetera. So you could sort of like layer local law on top of the Fair Credit Reporting Act, or you could look into, do we want to have a practice where we do some of these cases, generate some fees, and support the practice that way?
Great. Well, so I asked the viewers if they wanted to hear about discretionary sealing, and they said yes. So I got a couple questions. Yes, if we could discuss discretionary sealing, should housing advocates or tenants be moving to seal eviction records following every case was one question. Yeah. Another question was, why don't we have the client or attorney ask the judge to seal the record in every case, especially where the tenant wins?
Right. So I think that's a great point. It's something that I'm about to start trying to do in my practice. We've had a really rough time in Massachusetts getting any judge. So the word sealing, it means different things in different states. Here we call it impoundment. Sealing is for criminal records. So sometimes it's sealing, sometimes it's expungement, sometimes it's impoundment, sometimes there are statutes, sometimes there are court rules, sometimes there's common law. But in any event, some sort of thing like this basically exists in a lot of states, if not all states. So, but often what you have to do is show prejudice to the tenant if the record is not sealed. And the pushback that we've always gotten is that the prejudice is not shown because the tenant can't either hasn't been denied housing yet or can't prove that a landlord was denying them solely because of the court record. So that's the pushback we've gotten from courts here. But in other states, people, Minnesota, Larry McDonough and others have made really good progress filing individual petitions. And so one of the things I'm working on now is trying to put together like a sample, really juicy, big sample motion for impoundment that tenants, even pro se tenants, could be handed with their pro se materials packet. Like in every case, file this thing, put it in the agreement at the end of a case where the landlord will not oppose and the parties hereby propose to go to the judge. Almost always you're going to need, I think probably always you're going to need a judge to sign off on it because they're protecting the public's right of access to the information. That's the struggle usually more than with the landlord.
Got it. Well, thank you all for the questions and for letting us know what you want to hear about. So kind of jumping back to where we were. So that was talking about, limiting the access to those records in the first place. And then we talked a little about the reports and limiting what goes in there. So now let's talk about the third bucket that you talk about, which is regulating how these tenant screening reports are used. Tell us about that.
And I think that applies not just to Tenant Screening Bureau reports, but to the information altogether, right? With criminal records, we don't care what the source of the information is. We just say, don't use somebody's criminal record in a blanket way. So just to back up a second, and people probably know this, but just to create a logical stream, with criminal records, there are throughout the country, including recently in Seattle, there's a brand new, really good one, ordinances that say blankets, policies that are that deny housing to anybody with a criminal record as a blanket policy without sort of an individualized assessment of that person and their history are unlawful. Okay, so there are some ordinances that just say that. There are people pursuing this as a disparate impact claim through individual either litigation or policy work, and that is building off what advocates got the Obama Justice Department to write up in their guidance, which is cited in the article. But we're not doing that as much with criminal records, right? So, I mean, with housing court records. So there's the disparate impact angle, and there might just be an opportunity to also just try to get the kinds of ordinances that we have for criminal records passed in the housing law context. In New York, there is, I forget the exact details of it, but James Fishman, again, like I said, I'm just reporting on other people's great work here. And others in New York have gotten something before the New York City Council that would, for example, bar people from merely discriminating against someone because they have a record of having been a plaintiff or defendant in a housing case. And that would be under the discrimination laws in New York, well, the human rights law in New York. So there are good examples, and Oregon has, I believe, a statute on this. So there are some examples out there.
Excellent. And they're all, I'll remind everyone, they're all listed and discussed in your clearinghouse article, which can be found at the address on your screen, povertylaw.org/clearinghouse. I'll also remind everyone that we would love to hear your questions. If you have any questions for Esme, let us know. You can use the live chat on the live stream on YouTube, or email me at Amanda Moore, MOORE, at povertylaw.org. So do you have any kind of just general advocacy tips or lessons that you've gathered from looking at what's going on across the country that you could tell our viewers if this is something that they may be interested in beginning to pursue?
I think, I think we all know what the problem is. I think that the fair housing, approaching this as a fair housing issue, might give us tools that allow us to break through what has felt difficult to break through. I think where policy, these seem like just general rules of legal aid work that some of the successes seem like these policy successes where it looks miraculous that somebody was able to get that done. But when you look at the history, it's because people have been collecting tenant stories meticulously over the course of years. They've been getting those stories in front of policymakers and in the press and in front of in the minds of people so that it enters the public consciousness. People start to believe this is a problem. We're just in Massachusetts having trouble getting the court system to even believe that this is a problem. Or, so just creating over the course of years the sense that this is actually a problem that's affecting people's lives. And it's on that you can then build the legislative success. Again, I think those are generally applicable. There's also sort of the Minnesota example of lots of little cases creating a culture where the judges are educated, especially on, for example, these sealing motions. Suddenly what seems like seal an eviction case, that's crazy, why would I do that, to, oh yes, we seal eviction cases, that's what we do here. And that's often just a strategy of bringing a few compelling cases up front and hoping that the judge then takes it so that all the pro se litigants that are going to follow in your wake at least get the benefit of the doubt.
What I want to ask you, so those are some great tips. Are there other resources that you could recommend to our viewers if this is something they want to know more about? Obviously, there's your article, your Nora's article, but beyond that.
Yeah, the footnotes in the article, but also Eric Dunn, James Fishman, and then Jith, Megan Nathan, whose last name I may have mispronounced, but who was one of the key people working on the California legislation, which is new. So these are fresh that's a fresh law. The three of them and I are going to be on a panel at the upcoming Housing Justice Network conference in DC in mid-October, and so you can really hear from them how they got these things done, because the three of them have really been very successful in their jurisdictions, and to kind of talk with them, I think that'd be a great place to learn, like, this all sounds great, but how do I get it done here and where I live?
Super. And we had a question come in from Chase. Chase asks, we have seen multiple courts telling tenants if they agree to move by a particular date, it will not be an eviction. What do we do with that information?
Oh, I wish I could ask a question back to Chase, but I'm going to interpret that as best I can. In my own practice, I certainly see courts and landlords attorneys telling tenants, don't worry, it won't be an eviction, so it won't impact you. But when in fact we know that landlords are denying housing to people, not because they've had what is officially considered an eviction, but rather because when you enter their name into the court database, it pops up and there's a case next to it, right? Just that fact alone, especially in tight housing markets. I'm in Boston, so it's crazy here. The vacancy rate's like 2%. So, it's a competition. The landlords have no problem just moving on to the next tenant. And so there, I think it's a process of judicial education. We've tried communicating. We've scheduled a lot of meetings with our court administrators to kind of raise awareness about this issue, and we are bringing them specific tenant stories of tenants who were no fault evicted, gentrification evictions, small children in the household, and you just show the story and how that person then searched for 9 months for housing, and and they had a voucher, so it paid the rent. Why else, other than the fact that they agreed to move out, there's no eviction judgment against them, still they can't find housing. So that's our next step, is the storytelling. We'll see where we go.
Got it. Well, Esme, thank you so much for being with us today. It's as always, this time has just whizzed past, but I do appreciate your time and appreciate everyone's great questions today.
I appreciate everybody being here, because so often we're just looking at our cases and then we close the case. And this is one of those things that affects our clients after we close the case. And so it's just great that we're all focusing on housing, our clients as tenants in a bigger sense.
Excellent. Yes, and I want to remind all of our viewers that, as I've said a few times during our conversation, that you can read Esme and Nora's article, Combating Tenant Blacklisting Based on Housing Court Records, a Survey of Approaches, at povertylaw.org/clearinghouse. If you enjoyed today's conversation and found some use in it and in Esme and Nora's article, please join our mailing list. You'll then be notified of future content and events that we have. You can find that at connect.povertylaw.org/clearinghouse. And I will remind you that the Advocacy Exchange is now available as a podcast. You can subscribe to the Advocacy Exchange on iTunes or wherever you subscribe to podcasts. And I'd like to invite you to join us for next month's Advocacy Exchange. I'll be joined by John Young. He's a senior attorney and the head of the Low Income Taxpayer Clinic at the Legal Aid Society in Louisville, Kentucky. We will talk about how tax law can pop up in family law, debt, and Social Security cases for our legal aid clients. My conversation with John will take place on Wednesday, October 11th at 1 o'clock Eastern, 10 o'clock Pacific, same time as today. And we hope that you'll join us next month. And until then, remember that you're not alone out there. Thanks.
Thank you.